It looks like Ms. Richards and Mr. Mills are both in the courtroom. So Mr. Mills, we are ready when you are.
Thank you, Judge. May it please the court, my name is Peter Mills. I represent Edward Massengill, the petitioner in this case, and I am requesting to reserve 5 minutes for rebuttal.
Very good, Mr. Mills.
Mr. Massengill, his case originated back in 1990. In 1995, the case was resolved at the trial level. He entered a guilty plea to a charge and not guilty by reason of insanity to additional charges, and he was adjudicated as such. He has since served his prison sentence and has been undergoing treatment. The treatment team that currently supervises him and evaluates him has recommended a change from residential treatment to a supportive housing setting. Prior to an evidentiary hearing that was set for this proposed change, the state moved to have Mr. Massengill submit to an evaluation by the state's privately retained expert. This was done over Mr. Massengill's attorney's objection.
Mr. Mills?
Yes, sir.
If I can jump in for a minute. It seems as though there's nothing specific that actually covers this situation of a state retained expert giving an evaluation in the posture of a modification of conditional release. There's no case law. There's no statute that's directly on point. There's certainly nothing that precludes the state, nothing specific saying the state can't have its own expert. So how can this be a departure from the essential requirements of the law when there doesn't appear to be any law that covers the situation?
I agree with you, Judge, that there is no case law, there's no statute, there's no rule that addresses it. When looking at it to determine whether or not it is a departure from the essential requirements of law, if you look at the other statutes that provide for state experts to compel a defendant to submit to evaluation by their hired experts, there are specific provisions for that, whether it's in pre-trial setting with not guilty by reason of insanity or commitment because of a finding for not guilty by reason of insanity, battered spouse syndrome defenses, whether it's a capital sentencing phase where the defense has given notice that they intend to provide mental health testimony by someone who has evaluated the defendants. Those all are specific provisions for that. Where it's not allowed is with competency evaluations. The court in those settings appoints the neutral experts, and that is the same way that this provision is set up according to the statutes and the rules.
Well, I think there is case law and rules that govern the situation for an involuntary commitment, but I don't find anything that would expand that to say that the state isn't entitled to an expert for a modification under these facts. I don't see it. If I understand your argument, I think you're saying that because there's no specific in writing authorization earmarking that the state has this right, that therefore by process of elimination, they don't have the right. Is that what you're saying?
Yes, Judge, because neither the Florida statutes nor the rules authorize a compelled evaluation by a state expert. The trial court would not have the authority or power to enlarge or improve or change that law. They cannot read words into the statute or the rules that do not exist. If the legislature or the Florida Supreme Court
doesn't your argument require that we read something into the statute that doesn't exist?
No, sir, because it's not authorized there. When the Florida Supreme Court and the Florida legislature intended for the state of Florida to have that ability, they authorize it. When you look at Article 1, Section 23 of the Florida Constitution, the Constitution specifically states that we have the right to be let alone and free from government intrusion except as otherwise provided herein. And because that is not specifically authorized, it should not be read into the rule or the statutes. Because there is no such provision for it.
At the hearing on the state's motion, it seems as though the judge he inquired several times as to the effect of it, don't I have the inherent power as a judge, since I'm supposed to conduct a hearing to see whether what's being recommended is safe for the community? Don't I have the authority to look at materials that may be helpful in that regard?
Well, he did ask questions about inherent authority, Judge, and he would have the right to review the medical records, the reports from Peace River, who is responsible for Mr. Massengill's supervision, and the records that come from Adele Gilbert, the residential treatment facility where Mr. Massengill currently resides. Absolutely. But compelling him to undergo a forced evaluation by a state expert, he does not have that authority. Trial courts have a great deal of inherent authority controlling what goes on in their courtroom, addressing abusive litigation issues and things like that. But compelling a party to undergo a forced mental health evaluation is not one of those things in this situation.
Now, in this situation, of course, the expert that's involved, Dr. Gamache, he'd already seen your client previously.
He had seen
over
Mr.
objection,
Massengill.
and I don't know whether I would like for you to address whether or not the fact that Dr. Gamache had already seen the defendant over objection, and nothing was done about that. There was no appeal taken or no exception to that. Does that foreclose where you want to go today?
No, Judge, it doesn't. And what you're saying is akin to looking at it as whether or not it is law of the case, as the state urged, and or whether it would be a harmless error issue. It's not law of the case because it didn't arise from appellate ruling. It was not raised beyond objection at the trial court level. I was not on the case at that time. It does continue to be an issue of objection for Mr. Massengill because there is obviously new information. The state asserted that because Dr. Gamache had previously seen Mr. Massengill, there wouldn't be any error or problem with him doing it again. This misses the point of what is really being sought. It's a new compelled mental health evaluation. If they weren't seeking new information from Mr. Massengill, they wouldn't be seeking a new compelled evaluation from him.
Okay.
So, as I mentioned, the state is permitted to compel certain mental health evaluations with pretrial issues and not guilty by reason of insanity defenses, capital sentencing, penalty phase issues, and battered spouse syndrome. That's not allowed here. Courts, when they appoint neutral experts, as the Florida Supreme Court talked about in Parkin, do so to ascertain mental capacity by experts that are neither for the state or the prosecution or the defense, but neutral experts. And their findings and their opinions are then subject to testing for truth and reliability by both the prosecution and defense. That sort of neutral expert is what's anticipated, the way the rules and the way the statutes are written at this time. The 10th Judicial Circuit maintains a list of experts that have undergone background checks and all agree to abide by certain directives within the local administrative order. And if there are complaints about the experts, there is a process for raising those complaints, and they've all been vetted by the court. Dr. Gamache has refused to go through that and is therefore clearly not one of the neutral experts that would be anticipated by the rules and the statute here. Now, because neither the rules nor the state authorize this compelled examination, this court should not, and the trial court should not have read in language that did not exist. And for these reasons, Mr. Massengill and I respectfully request that the court grant our writ, quash the order compelling him to undergo a compelled mental health evaluation by the state's expert, and allow us to proceed on with the evidentiary hearing and hopefully follow the recommendations from the people overseeing his commitment at this time, so that he can proceed to the supportive housing.
Very good. Thank you very much. Ms. Richards?
Good morning, Your Honor. Cindy Richards for the Office of the Attorney General in the state. Judge Black, I would like to first address your point that you said this isn't a departure from the essential requirements of the law to obtain the writ. Well, the state's position is it is not, and it is not for several reasons. Partially because Dr. Gamache has examined the petitioner previously, but it's not just that. This is a procedural argument. This is not about privacy because, as you pointed out yourself, Judge, Dr. Gamache has already evaluated the petitioner. He has his medical records. And I mean, to be honest, the argument that it's a privacy issue and the state is somehow trying to force the petitioner to be evaluated is simply in error. There is no privacy because, as the defense points out, even if we were to use the appointed judges off the registry list, that waives any right to privacy. The state attorney's office, the defense counsel, and the court are all entitled to access to the petitioner's medical record. The only issue with the registry list is who foots the bill for paying for the expert. I think defense counsel just said that they are neutral experts. That would assume that any other expert, medical professional, doctor, psychologist that was hired by defense, private defense, or by the state attorney is inherently not neutral. That's like assuming, if one of the parties hires a medical doctor, when a patient has cancer, you get to pay him to say that, he died of alcoholism. That's not an issue in this case. They're neutral and they're both experts. By saying Dr. Gamache refused a background check is also not true. Again, the registry list is merely an issue of who foots the bill to pay for the expert, whether it's one of the parties or whether it's the court itself. And in this case, I would like to remind the court of the facts. Petitioner, from the record, you can see that he was adjudicated guilty of second-degree murder in 1995 and not guilty by reason of insanity of second murder charge. He was sentenced to 27 years, but part of the plea agreement the petitioner took back in 1995 was that after his 27-year sentence for the second-degree murder charge, because of the not guilty by reason of insanity, he was going to be sent to Department of Family for evaluation. What's happening at this time is the petitioner is requesting a conditional release. By asking for that change in his circumstance, he's waiving his right to privacy. He has to be evaluated because he is still under the jurisdiction of the trial court based on his plea agreement from 1995. And I'd also like to remind the court that in 2005, he was paroled and given conditional release, and 80 days later, threatened to kill any police officer, cut off his monitor, and absconded. This man has been diagnosed a violent schizophrenic and is a danger to the community. And I think having an expert, and during the evidentiary hearing, defense counsel admitted that the state has every right to hire an expert witness, but they limited it to that Dr. Gamache could only review the records provided to them by the defense. So Dr. Gamache should have had, by their own admission, availability to petitioners' medical records, but could not interview or evaluate petitioner himself. And Judge, you also brought up whether there's no case law or statute. That's true. In the state of Florida, there is not. However, if you look at some of the statutes that are involved in the not guilty by reason of insanity, for example, 916.115, that statute specifically says the court shall appoint no more than 3 experts to determine the mental condition of a defendant involved in a criminal case, including competency to proceed, insanity, involuntary placement, and treatment. Well, that directly relates to what we're dealing with in this particular case. It does not say anything as to who pays the bill, or if the state can ask the court to appoint the expert of its own. However, it also doesn't say that defense counsel can ask or provide their own expert witness. And as this court knows, this happens every day in trial court. If you have a private attorney, or even with the public defender's office, if a defense or a defendant chooses to hire their own and pay for their own expert witness, this is a normal practice in every court in the state of Florida. That's not specifically discussed in the statute. So the argument that just because it says, doesn't specifically, the state may petition the court for an expert, doesn't say the defense can either.
Ms.
And
Richards,
as far
one question.
as that under
Ms.
the same
Richards.
statute and
Ms. Richards.
subsection 2, I beg
Ms.
your pardon, I'm
Richards.
sorry.
One question that I have for you is, in the rules of civil procedure, there is a rule specifically allowing for independent medical examinations. There's no comparable rule in the criminal procedures, correct?
Well, this 916.115 does specifically discuss competency, insanity, and how to proceed.
But not independent medical experts, a rule similar to that in the civil procedure rules.
That is correct, Your Honor. It does say, the statute says experts.
Okay.
It doesn't say independent or otherwise. It just gives the court the authority to appoint no more than 3 experts. So, I mean, but as I said, it doesn't say they can't be requested by one side or another.
And this entire proceeding was initiated at the request of the defense to alter the conditions of his release. Is that correct?
That is correct. He's, as I said, he was paroled in 2005. This parole was revoked. He went back into prison. His prison sentence is now finished. Now he's under the guise of the involuntary commitment because of the not guilty by reason of insanity. Back in December of 2018, he petitioned the court, and the court did allow him to be released on conditional release at that time over the state's objection. Since then, and I think this is the issue that the defense is trying to avoid, but I don't really understand why, because they're entitled medical records regardless, that the conditional release was revoked again at that time because the petitioner in this case was Baker acted in 2020 and was sent back. The trial court sent him back and revoked his conditional release. Now, this is, again, a new request for conditional release based on, it is the same 2 registry list doctors. And as you pointed out, Judge Black, that Dr. Gamache was one of the 3 doctors that evaluated him back in 2018 for that release, or I'm sorry, 2020. And the trial court noted in its order that Dr. Gamache had over 33 years of experience, while the other two doctors had at that time less than 5. Obviously, they have more years experience now, but back at that time, less than 5 years experience. And the trial court relied exclusively on Dr. Gamache's written report as the basis to deny conditional release. And this is really the crux of the matter of what we're discussing here now. But in other statutes, and Judge Silverman, you are correct, when it comes to criminal case law itself, it's not as spelled out as it is in our civil case law. However, 916.17 Florida statute on conditional release, it also states that under filing of an affidavit or statement under oath by any person that the defendant has failed to comply with conditions of release, defendant's condition is deteriorated, that inpatient care is required, which is what happened when he was Baker Act in 2020 and why he was returned to inpatient care. The court shall hold a hearing and after receipt of the affidavit or statement under an oath. Now, this is the same as what's happening now. Defense, the doctors that evaluated him along with Dr. Gamache last time have now written care, and Peace River, who supervises this, have sent in an affidavit saying that in their opinion that he is eligible for conditional release now. To say that having the same doctor that evaluated him last time not be able to reevaluate him this time, especially since that doctor's opinion varied dramatically from the other two doctors, it makes no logical sense. He's already evaluated him. He has his medical records. And the state should have an opportunity to basically cross-examine in this case. The last thing I will point out, as far as I'm saying, this is just merely procedural, which why it doesn't even rise to the level standard where a writ of certiorari can even be issued in this case.
Let me interrupt, because you just said something that interests me. You said that the state would be entitled to have an expert to cross-examine or assist in the cross-examination of the state's, the neutral experts and any other evidence that the defense provides. You would be entitled to use an expert to do so. But the issue here is whether your expert is entitled to do his own independent mental examination, correct?
That is correct. But to remind the court, the expert has already done.
No, I understand that, but you're asking for an additional independent mental examination. How does that impact the state's ability to cross-examine the state's, or again, I keep referring it to the state's, the independent experts who would be appointed?
Well, it would be, to put it in a different way, let me put it this way. In December of 2018, when the trial court granted the petitioner conditional release, on that time, the petitioner signed an agreement, which is similar to a parole or a probation agreement called, and in the general conditions of this conditional release agreement that was signed by the petitioner, number 9 said that he signed to understand that even though I may not have violated any conditions of release, I may be rehospitalized or placed in a crisis stabilization facility if my mental health deteriorates to such a point that hospitalization or stabilization is necessary for my safety and or Judge Black, the safety of the community. Under that was part of the general conditions of the agreement. Under specific conditions, number 8, petitioner signed that he agreed to cooperate with all requests for psychological testing. This was signed by the petitioner on 12/14/18. It didn't say all requests depending on who was paying the bill. It said all requests. I can liken this to a probation or parole type of when you are released, like a conditional release, and you're on probation, the police are entitled to knock at your door at 4 a.m. or search your house or, stop you and question you. This is the same sort of agreement. So as far as relating it back from civil law to criminal law, where we don't really have it as spelled out, that would be my argument, that for no other reason, under his conditional release agreement that he signed in December of 2018, he was made aware that he could be back in conditional release revoked. He could be examined and at any time. And
So was that I don't recall this, was that agreement mentioned in your brief?
I believe it was, Judge.
I may have just forgotten about it.
I could be wrong, but I believe it was. It's in the record. It is in the record. And that's why he was Baker Act in 2020 for threatening to carry out his verbal threats to kill. So,
Very good.
and here we are, a year and a half later, 2 years later, and this is an ongoing cycle. Because he's not guilty by reason of insanity, he is under the trial court's jurisdiction. He has been released on conditional release and returned because of his mental health deteriorating. This isn't a privacy issue. This is a procedural issue. But in either circumstance, it doesn't even come close to meeting the standard of what a writ of certiorari should be granted for. And in this situation, the state is going to ask you to deny the writ, Your Honor.
Very good. Thank you very much.
Thank
Mr.
you.
Mills?
Thank you, Judge. I have several things that I would like to say in response to the state's argument. This is an issue about privacy. Article 1, Section 23 of the Florida Constitution does apply. The issues with Dr. Gamache. Dr. Gamache did evaluate Mr. Massengill in the past. And if you review the record closely, you'll see that he triggered Mr. Massengill through aggressive tactics in his evaluation, such that Mr. Massengill and counsel got up and left the evaluation. Now, contrary to the state's urging,
And that could happen. That could happen in this. If this were permitted, that could happen again, correct?
if Dr. Gamache attempts to trigger him, and that didn't happen with any of the other neutral parties. The issue.
And would your client be able to refuse to answer any questions during the examination, and then the court can determine whether or not that's warranted or not warranted, or if the doctor is permitted to testify, he then says, well, the independent experts got this information. We can't challenge it because he refused to answer our questions. So, Judge, he is refusing to carry his own burden to establish a change because he's not cooperating.
I could see an argument being made that way by the state if there was a question that he refused to answer, perhaps on advice of counsel. Then that is an issue, as occurs with depositions, in which the matter could be brought up before Judge McDaniel, and we address it there, and he issue an order saying, you're going to answer this question and anything that would reasonably relate to it. One of the things that the state continually said during their argument was that Mr. Massengill's conditional release was revoked. Mr. Massengill has continued to be on conditional release. He was briefly Baker acted and almost immediately returned to Adele Gilbert, and it is Adele Gilbert and Peace River who have been supervising him, evaluating him, dealing with him on a daily basis, who are making the recommendation. They are contractors of DCF. They are the party, or I'm sorry, they are the people who made the recommendation that Mr. Massengill proceed to this supportive residential housing assignment. The issue with this being simply who foots the bill is an inaccurate statement about what's going on. As the Florida Supreme Court said in Parkin, when the court appoints experts, they are neutral. They are the court's experts. This is an expert who has had obvious issues with Mr. Massengill or Mr. Massengill had with the expert. The other doctors who evaluated Mr. Massengill had no problems with him and all recommended that he proceed or progress into this supportive housing.
Well, what about the argument that the state presented that the conditional release agreement essentially allows the state to do what they're asking?
That conditional release agreement doesn't specify that he see an additional state expert. It's written very broadly and certainly didn't contemplate this issue at that time. If it did, or if it was going to, it would have stated it specifically, just as the rule addressing this issue would have, and the legislature would have done so with the statute.
And you've got about 15 seconds to conclude.
Thank you, Judge. The argument that the state made that the defense could always have the doctors of their choice see him ignores the truism that defendants can always undergo evaluations at the request or direction or agreement with them with their attorney. There's no involuntary compulsion there. And so, as I stated before, we are asking that you grant our petition for the writ and quash the order compelling the petitioner to undergo this mental health evaluation by the state's hired expert.
Very good. Thank you both very much. And that concludes the argument for that case. The next case is Progressive American versus Glassmedics.